I think we got good information for them.
I think we have very good information for them. There's a lot of options that people just don't realize they have. So it's hard to make informed decisions about what to do when you lack information. So I think it'll be very helpful.
Good. And hopefully we don't get too big of a storm this afternoon.
Oh, we were supposed to get one yesterday as well.
Well, it did rain last night.
It did, I suppose. Not quite as much drama, I think, as we were thinking about.
I was expecting it to be windier.
Yeah, I was too. Considering the electrical strike we had recently at the office, I was a little worried. I almost had everybody unplug everything in the office before leaving.
Well, it's better to be lucky than good sometimes.
Safe than sorry, right?
All right. Well, welcome. I'm attorney Peter Harbach, and this is attorney Sarah Kahns. We're estate planning attorneys from Hooper Law Office, and we're teaching a class now about protecting loved ones in your estate plan. So we've got a number of materials for everybody who's registered for the class. You have to be registered to get these. So if you're watching on Facebook Live without having registered, welcome, but we don't have you're not getting the materials. So we've got protecting loved ones from themselves and loved ones from others. Sort of a breakdown of the different topics we're going to be talking about today, because there's a lot of scenarios where people are concerned about family members, grandkids, young people, beneficiaries who might have some special circumstances, and they have a tendency to not have any idea that they can fix these problems or at least alleviate some of their concerns through their estate plan. So that's really what we're going to try and highlight today. Just a plug for our next session, next Wednesday, June 17th, again at noon, we're going to be doing another one of these classes. And it's going to be on wills and trusts and some of the differences in planning between those. So let's jump into today's topic. Like I said, a lot of people have certain things that they might be concerned about for their loved ones, and not realize that there's different ways to protect, the loved one from themselves or from bad circumstances. But one of the first steps, and one of the easiest things that you can do in your estate plan, and this is going to sound repetitive from some of the other classes if you've been watching this in a series, but you can't overstate the importance of it. One of the first steps in protecting anything would be to have a power of attorney yourself to make sure that if you become disabled, you have somebody that can handle your financial matters for you. Now, in the context of if you have minor children or anything like that, you yourself have to make sure that you've got a power of attorney, because somebody needs to handle your finances to be able to help that child. Mm-hmm. People don't just naturally have access to your bank accounts and whatnot if anything happens to you. So if you have any loved ones that rely on you, you have to make sure that you've got your own stuff in order. And if you become disabled, you need a helper to step in and access those funds for both you and this person you're taking care of. So a power of attorney is a critical and fairly simple step. If you're concerned about long-term care expenses as part of your overall estate plan, you're worried that, boy, if I'm faced with nursing home expenses and they're in excess of $100,000 a year, or whatever amount might be scary to you, and you're thinking, boy, that would really go through my estate very quickly, but I need to make sure I have some of this estate because I intend to pass it on to somebody who is maybe reliant on me, a young person, a person with a disability, just somebody that you're really trying to be able to help if you pass away. Power of attorney can provide powers that allow that agent to step in and try and protect some amount of those funds that would have otherwise gone to the nursing home or to those long-term care expenses. But your power of attorney has to say that it provides those powers. Because if it's silent on this issue, then you have not given those powers to your agent, and they're incredibly limited on what they might be able to do to try and protect things. And again, your goal might be, I need to make sure something is protected to take care of my loved ones. So when we're talking about protecting these people, the first step is, okay, let's make sure that you have something left that you're going to pass on to these people.
Well, it's important too that you minimize any kind of disruption that your loved ones may experience because you're no longer at the helm of the ship, basically. Whenever I do planning for families that have minor children, one of the other things that I'm talking to them about is a power of attorney for minors. So if you are, let's say the parents are going to go do a second honeymoon or, something out of the area, out of the country in particular, and the kids are being left in the care of another family member or a trusted friend, the parents are still the only ones that can make a lot of very important decisions, especially in emergency situations, particularly for medical issues, but for other issues as well. Ensuring that you're nominating somebody to have the authority to make important decisions in your absence can be crucial in an emergency situation. So even babysitters for shorter periods of time, things can happen with kids, especially young kids, they get into things. So making sure that you are providing what is necessary for a babysitter or a family member that may be providing care during a period of time, the ability to do these things until you are able to return and be there yourself can really alleviate a lot of stress in an emergency situation. So often I provide these to clients that I'm doing planning for.
Absolutely. One thing I neglected to mention during our opening statements here is there's a question and answer box if you're registered for this class. And so if you have questions, we intend to make sure that we do our best to answer them at the end of this session today. So feel free to type in any questions you might have, and we will do our best to respond. Okay, so that's a little bit about protecting people during somebody's lifetime. While the parent or guardian or the person who is intending to provide for these people is still alive. And I guess the last thing I'll mention on that topic is even young people should have an estate when they die. And what I mean by that is there should be money, even if you are a young, not very even maybe financially secure couple. If you have minor children, you have no excuse to not get some life insurance, which a lot of people are very surprised is much more affordable than they might have anticipated. And so, talk to a life insurance agent, or if you have a financial advisor, talk to them about what available options you have, because especially for younger people, there's just no excuse to not die with a fairly substantial estate, because life insurance is not on average a particularly expensive thing to do. Because insurance companies are kind of assuming that a 25, 35-year-old isn't likely to die on them. So they price the premiums fairly reasonably on that kind of stuff. And so if you're worried about taking care of somebody, life insurance is a good step to look at.
Usually a working parent has options through an employer, but you don't want to just rely on that, especially if your job situation might change. Maintaining life insurance yourself is important. And it's not just to replace somebody that's bringing money into the household. An individual that is maybe staying home with kids, where they're not bringing as much financial resource into a family, they're still providing a lot of valuable activity.
That would have otherwise been really expensive if you were paying somebody else to do it.
Exactly. Things like daycare services, cleaning, errands, all sorts of things that you can hire somebody to do, but there's an expense to it. So you have to keep in mind, even if it's the person that is not outside of the home working and bringing in a lot of resources, if the parent that's at home passes, you're still replacing what it is that they're doing in the home with somebody else, where that may be a significant financial expense. So life insurance on them is equally as important. If you talk to a life insurance agent, they'll be able to walk you through the options that you have and how much should you be insured for, and that does change over time. So you should have that reviewed regularly. But Peter's right. Life insurance, especially basic term insurance for a young person, is very affordable, and it can mean the difference between stability and a lot of disruption for your family because of an unexpected loss.
Yeah, getting down to one parent who's trying to still work, and there's still a mortgage and kids to pay for and all of that. That can be an incredible struggle. And even with an infinite amount of money, that's an incredible struggle. But you slap a significant financial burden on top of that, and just a terrible position to be in. So, again, life insurance is a good step on that. But for people beyond just those with minors and whatnot, there's a lot of planning that can be done when somebody passes away in their estate plan for how to protect the people that they love. And we have a tendency to talk about this in the context of protecting people from themselves and protecting people from others or bad circumstances that they might encounter throughout their lives. So protecting people from themselves would include, sort of known situations about your loved one that you intend to pass some of your hard-earned assets on to. So that could be, hey, I know that I love my grandkid, but he's 10, so I'm not going to leave him $100,000 because that's just going to turn into video games because he's 10. And so it's not that person's fault themselves that they're young, but it's also, foolish to leave any unrestricted money to a minor child or to somebody who is, frankly, maybe not even a minor, but young enough where they're not necessarily a real adult. I mean, you're an adult at 18, but you don't necessarily have full impulse control when you're 18. I know I didn't necessarily. It would have been foolish to give me hundreds of thousands of dollars. And
young people tend to focus a little bit more on what can this money do for me right now?
Yeah, what kind of fun can I have with this right now?
Right, rather than what can this do for my future?
Exactly. And, it doesn't have anything to do with necessarily how smart the person is. They can be a straight A student. That doesn't mean that they're going to be responsible with an inheritance when they're at a young age. I mean, I did really well in school. I would have done terrible with a chunk of money landing in my lap. It would be gone, and I would have had a lot of fun, but it would have been nothing that really built my future. So, on average, it's just a bad idea to leave funds directly to a young person. Another example would be, regardless of age, somebody who's just never been able to kind of keep a dollar in their pocket. And everybody knows somebody who's well over the age of being an adult, yet, can't seem to keep money in their pocket. They're spending foolishly. They're making maybe poor decisions. And if this is somebody that you otherwise love, and you say, yeah, I absolutely want to leave something to them, but I don't want to just turn it into, a couple of trips and a new car that they don't actually need, because I spent my whole life building this up. And I care about them and I want to provide for them, but I'm concerned about, how they're going to treat this money. Again, age is not always the only factor in that. You can have a 55-year-old son who just doesn't have his act together. Another situation is somebody who has drug or alcohol issues. I've had numerous clients where during the conversation about their estate plan, they've actually said to me, I love my son or daughter, but if I leave them any money, I'm worried that they're going to kill themselves with it because they're just going to turn it into drugs or alcohol. And so, what solutions do we have to make sure that they cannot do that? And then, an individual who has a disability or a special need is another situation that needs some special handling and provisions for.
An individual with a disability is a more complicated question in a lot of ways. It depends on the nature of the disability and what exactly they may be using in terms of benefits as to what exactly the planning for them should be. One important consideration is the outdated assumption that you have to disinherit an individual with a disability in order to provide for them appropriately. You can absolutely include them in your planning. You can make them an equal beneficiary with everybody else. You don't have to treat them differently in terms of the division of your estate. You just have to make sure that you're using certain planning methods to ensure that whatever you might be leaving to them is not a replacement for other things that they may be benefiting from. Certain programs, certain benefits that they can be entitled to based on the nature of their condition. A lot of those have financial qualification components, and you don't want to leave a sum of money, especially not one that can permanently replace all of these benefits so that they get kicked off and then just have to reapply and get back on at a later time. So there's very specific ways to plan for this, but it's very situation individualized. So you want to make sure that you're speaking to somebody that does planning and special needs. But yes, you can absolutely include them. They do not have to be disinherited.
And so generally for these situations where you're concerned about the person themselves receiving these funds because of either what they will do with it, because of the young age or the inability to preserve money or the substance abuse issues, or by circumstance they just can't receive a direct inheritance, or they're going to lose all these benefits that they're maybe very reliant on, then what you'd be doing in your estate plan is providing the power and control over the assets to somebody else that you've chosen, that is going to be a responsible sort of steward of the money, either for a period of time or maybe the rest of this person's life. So for instance, if it's an individual with a disability and it's not any kind of short-term disability, it's something that's permanent, well then that would probably be a lifetime steward of the money. If it's maybe just because of younger age, you might be saying, okay, I want somebody else who is responsible, that I've vetted and chosen, that I know is going to do a good job, to be in charge of the investments and spending until my child is, say, 30 or 35 years old, where, yeah, I think by that point, they would be capable of managing an inheritance in such a way that it's not just going to turn into a great spring break for them and their friends. So again, you're choosing somebody who is in charge of these funds. Now, this can either be an individual that you know yourself. It doesn't have to be a company or any kind of outside source if you don't want. If you have a responsible person that you care about and that cares about your beneficiaries, you can select them if you know that they're willing to act in this capacity. If not, if you're thinking, yes, I have these concerns, but I don't really have anybody in my family or personal life that I can rely on, or maybe the only people that I could rely on are much older and maybe won't be around or capable by the time something happens to me, well then either as a backup option or the initial option to start with, that's where you can use companies or professional fiduciaries to step in and act as the steward of the funds to make all the management decisions. And then the beneficiary has to come to them to request funds. And then they can, you have somebody responsible who's saying, yes, you can have this, or no, that's not an appropriate use of what mom or dad or grandma or grandpa, that's not what they intended with these funds. So that's a little bit about protecting people from themselves, these sort of known circumstances that we might be concerned with. But there's also protecting individuals from bad circumstances or bad actors. Sometimes this is sort of summarized as predators and creditors and just bad things that might be out there. And that kind of planning can be part of this protecting people from themselves, but it doesn't always have to be. You might have the world's most responsible child who is absolutely capable of managing an inheritance and is not going to spend it on drugs or alcohol and is going to be, a good steward of their own inheritance. But you should know that you're capable of providing a level of protections over the sorts of bad things that might happen to them even years after you die. It doesn't have to be something that has happened before you pass away. You could protect things for many years after you've passed away. And again, even for very responsible people. And this is probably some of the most popular type of planning that we end up doing, because most people say, as part of this process, I had no idea I was able to do this. Why doesn't everybody do this? And, my usual joking comment to that is, well, did you know you could do this before you came and talked to me? And it's, oh, no, I guess I didn't. So that makes sense. So what are the types of circumstances that people might, a loved one might find themselves in after the death of the person who did their estate plan that we can provide a level of protection over?
Usually when I talk to my clients about this, I start this conversation out with, it is difficult to protect your own stuff from your own liabilities. It is very easy to protect what you're leaving to somebody else. So even though this is not something you can do for yourself in quite the same way, this is a gift that you can leave with whatever it is that you're passing on to your beneficiaries. Some of the more common things that we talk people through are lawsuits. Even just car accidents can result in legal issues. So ensuring that the assets that you are passing on, you're providing the most amount of protection for that you can against a circumstance like that. Another very common issue that people can run into, bankruptcy, foreclosure, things like that. Right now, probably one of the most common reasons for bankruptcy cases are medical expenses and medical debt. So it's something that can happen very quickly to people, where there's a spouse maybe that gets sick, and over a period of maybe just a year, due to medical expenses, inability to work, things like that, things just pile up very quickly.
Yeah,
so
I actually had a case a number of years ago where I had done what we refer to as long-term care planning for a woman. She was in her 80s and her kids were all in their late 50s to early 60s. And everybody's responsible, and there was no concerns about the kids and how they were going to treat an inheritance. A few years later, the woman, my client, passed away, and one of the big concerns was there was some hardship on one of the kids between the time that we'd done the planning and the time that my client passed away. And so the big concern, because the child had just filed for bankruptcy prior to mom passing away, and under normal circumstances, you have to disclose an inheritance and it can get attached by the bankruptcy court and divided up. Well, thankfully, my client had chosen to provide a protection to the children within her estate plan. And so everybody was getting equal shares. So 1/4 of the estate was going to the son, who had just filed for bankruptcy. And we had to turn over a copy of the estate plan to the court, but it was deemed unavailable, which means it was protected and didn't have to get exhausted by the bankruptcy proceedings, which, I like to think would have made my client very happy, because, she'd grown up with very modest means, and she was really hopeful that she was going to be the first one to ever pass on an inheritance to somebody else in her family line. And just knowing that not only was she able to do that, but it was actually going to do some good for the family and not just lost by the bad circumstance, it made all the difference in their particular situation. So that's just more of a concrete example of the types of protections we're talking about here. Okay, so bankruptcy protections.
Bankruptcy, foreclosure as well, house loss, things like that. People have experienced that over the last decade in probably a few different ways. And then probably one of the most common things that we talk to our clients about and that they're concerned about is divorce. So the idea of a divorcing spouse being able to demand a portion of or access to or payment from any sort of asset you might be leaving to a loved one. I mean, what you want is to make sure that it's available to the loved one themselves for the rest of their life, and that it's not going to be divvied up by something like this happening.
And, and sometimes these are unforeseen. You just, boy, I never would have imagined that they would have got divorced. But if it would be your intention that it goes to your child and isn't divisible, you can make sure that even if they were to get divorced many years after you passed away, that there's that protection from that division. Also, even if it's not an unforeseen circumstance, you got a son-in-law you didn't like, and you think, boy, why'd she ever marry her? You can build into your estate plan an inability for him to ever get anything. Frankly, even if they didn't divorce, you could build that in there to make sure it stayed in the family line and was not, if she passed away, able to go to him.
That does also tend to be a priority for some clients, ensuring that making their client or their child the recipient of their estate after they pass. What happens when the child then passes? Even if you're not leaving assets to a young person directly, but they could potentially receive from you. That's where a lot of these protections can come into play. They're not always, I know for sure that this is what's going to happen because that's how I've created my plan to work. It's what happens if things are not exactly the way that I intend them to be. If I was able to predict the future, my clients' estate plans would be 1 to 2 pages long because you know exactly what's going to happen. But most estate plans are multiple pages because you're not only trying to include, this is what I want to happen if everything is exactly the way that I'm expecting it to be. You are also including a lot of different backup plans or contingency plans. So you are giving direction to your loved ones as to what they're supposed to do if the situation is a bit different, or if things change even after they've received the inheritance from your estate. So as their circumstances can change over their lifetime, or if they are able to then pass it on to their loved ones, you want to keep that protection getting passed to each loved one. Again, this kind of thing is difficult for you to do with your own property. That's where you hear about like offshore bank accounts or domestic asset protection and things that tend to get a little fancier because you're trying to protect your own stuff from things that happen to you. When you are passing things on to somebody, you can set the terms for how they receive them and build protection into that passing. So you really have a unique opportunity at that time to do that.
And another thing that has a tendency to take up some pages in an estate plan is making sure that there's good tax planning within the plan. And this is another protection that you can pass on to your beneficiaries. Right now, under the current laws, we're at an all-time high for a per person estate tax exemption that I often refer to as a coupon, that individuals can pass a certain amount of assets. Right now, it's right around $11.5 million that you can pass without a separate estate tax getting attached to it. Well, it doesn't matter what the law is right now so much as it matters what is the law at the time that you die, because that's when the tax gets levied. Well, there are a lot of advisors who are expecting that coupon, that estate tax threshold, to go down in value in coming years, in part because, for example, there was just about a $4 trillion spending bill passed in response to the coronavirus. So some advisors are saying, boy, the money's gonna at some point have to come from somewhere. Potentially, this means that they're not going to have such large estate tax coupons in the future. I have no idea what in the world the estate tax is going to turn into at any point. But if some of these advisors are correct and they reduce significantly this estate tax amount, well, you can have built into your estate plan that the money you've passed on to your children are not part of their estate when they later die, to get added in what you've left them, added into everything that they have themselves, and then have the coupon apply to that. You can say, okay, what I passed on to my child is not part of their estate when they die. So it's not included. So in case that estate tax coupon goes down a lot and they'd have had to pay a significant amount, which can be 40% of somebody's estate, and not too many years ago, it was up to 55%, you can make sure that if these laws change, what you've passed down to your child is not part of their estate. Even if they don't change the laws, but you have a very successful child who maybe has millions of dollars on their own, you want to look into this to make sure that when they receive it, they don't just add it into the pile that gets taxed. So lots of different considerations there. So we talked about protecting from lawsuits and creditors and bankruptcy and taxes and divorce.
One other really common example that often gets overlooked is the idea of a business owner. If you have a child that owns and operates their own business, whether or not their business is creating a lot of money for them, and we're talking about a higher net worth child that you're doing tax planning for, there's also the liability side of things. I mean, being business owners ourselves, we can understand this. If you are operating a business, you may do things like sign personal guarantees if you take out business loans, or if you have an actual brick and mortar location, it just makes it more likely that you would get sued if somebody's hurt on your premises. So there's insurance and other things that you can do to try to mitigate that as well. But it kind of goes back to, you have a unique opportunity to do this for somebody that you care about. If you're planning for how you're leaving this to this individual, you can protect it. So if they do, if their business does fail and they have these personal guarantees, or if there is a lawsuit of some sort, what you're leaving them is sort of a financial safety net that they can go back to, that it isn't going to be subject to, these types of creditor issues.
Yeah, they have a level of protection from bad circumstances that happen through that business.
And it's not one that they can get for themselves in this way. And that makes a big difference.
Yeah. So that's a brief overview of some of the opportunities that many people don't realize they have through their own estate plan. So if any of what we just talked about resonates with you about your individual circumstances or things that you want to make sure are built into your estate plan, you can feel free to contact us. We provide initial consultations via Zoom or by phone call. We are not doing face-to-face meetings quite yet in the office, just out of an abundance of caution for the coronavirus. But if any of this stuff appears to be important to you and you want to follow up on your own situation, feel free to give us a call. And we have, like I said, complimentary initial consultations where we run through your particular circumstances and talk about whether or not any of this sort of protective planning might be appropriate for you. So hopefully you found this valuable information. Again, we're going to be sending out a number of different materials for those who have registered. And our next class is going to be June 17th at noon, which is another Wednesday.
And it's on wills versus trusts.
So thank you all for your time. And we hope to see you again next week. Everybody take care and stay safe.
Bye, everyone.